first of which is the estate of Reva case versus KKS Park Family Limited Partnership. It's case number 29-439. Each party will have 15 minutes, as both of you probably know, to present your arguments. The appellant may reserve up to 5 minutes. If you haven't argued here before, we do have the clock on the television screen. When it starts, the top 15 minutes will start running. Some people get confused once that hits. Let's say you reserve 5 minutes. You're at your 5-minute rebuttal time. Okay, just to clear that up for everybody. We have read the briefs and we are prepared to proceed if you are. Of course, we do videotape the arguments, so we ask that you stay at the podium, keep your voice up, and any reference to children, we use initials. Counsel, you ready?
Thank you, Your Honor.
All right.
May it please the court, counsel, my name is John Burke. I represent the estate of Reva case. I'd like to reserve 5 minutes for my rebuttal.
Very good, thank you.
This is an action for negligence whereby Ms. Reva case, an 87-year-old woman at the time, fell on October 1st, 2015 at the property owned, controlled, and maintained by the defendant. Ms. Case fell when she was exiting the building in the handicap ramp area, which was not in good condition and also had a hump in it. The trial court, defendants moved for summary judgment, and the trial court granted that motion, finding essentially two things. One, that the plaintiff could not identify the cause of the fall, which we believe is untrue, and on the alternative, that it was an open and obvious defect that caused the fall. In the trial court's opinion, it came to the conclusion that Mr. Edward Case, the plaintiff appellant's son, that he somehow suffered from dementia, and she discredited his testimony. First of all, there was absolutely no evidence whatsoever to support the claim that Mr. Case suffered from dementia. And the court coming to that conclusion, by the way, on its own, there was no argument made by the defendant that this in fact was the case. That clearly demonstrates that the trial court improperly weighed the testimony. First of all, by coming to an unsupported conclusion that Mr. Case suffered from dementia, when in fact he did not. And secondly, it shows that she then disregarded his testimony on that basis. That in and of itself should be a reason to reverse the trial court's decision granting summary judgment, because as we all know, at that stage in the litigation, a motion for summary judgment, the trial court cannot weigh the evidence. It doesn't matter how much evidence is on one side or the other. If the evidence presents an issue of fact, then the court can't weigh it. And in this case, Mr. Edward Case, although he testified that he couldn't see what specifically made her fall, he was still in the doctor's office and he's looking out through a window and he sees his elderly mother fall. And albeit true, he testifies, hey, at that time, I can't see what happened. I can't see what caused the fall. But says when he went outside to see his mother now on the ground, he then did observe exactly what he believed caused the fall. The defendant appellee's position, and the trial court agreed, was that he couldn't say what caused the fall. But that's not true. He did go out and specifically observe the defect and what caused the fall.
Counsel, I have a question.
Yes, Your Honor.
And I want to go back right to the initial portion of your argument regarding the trial judge basically weighing credibility, which we agree would be improper in a summary judgment. Did the trial court really do what you said? I mean, yeah, there's definitely a mention of dementia, and I'm not quite sure why, but it's in there. But did the trial court discount that testimony because of any alleged dementia or lack of remembering, or was it for the reason you just said? Nope, he didn't see it, that therefore he also cannot state, why she fell, which you disagree with, but you
Correct.
see what I'm saying, there's a difference there in how the trial court looked at his testimony.
I understand your question very well, Your Honor.
Then, thank you.
For some reason, the court states, and this is the court's quote that's in the opinion, a review of Edwards' deposition reveals he too has dementia. And the trial court put that in there, right in the area of the opinion where she was indicating that we couldn't show how he felt. And at the same time, we did present very specific deposition testimony where Mr. Case says, no, I didn't see where she fell at the exact time she fell, but I went outside and I observed exactly the spot where she fell. I've been thinking about how to kind of give an analogy of this. And, our jury instructions always talk about, you can come to reasonable conclusions. For instance, if I go to sleep at night and there's no snow in my yard, but I wake up in the morning and the snow has covered my lawn, but I never saw it snowing, okay? I can still say that, hey, it snowed, which is the same thing here. He sees her fall, but because the window blocks the view below about her knee or so, he can't see at the exact moment what caused the fall. But he does immediately go out there, and then he sees exactly what that fall was. So I believe that is an issue of fact that should have precluded summary judgment. The other part of the summary judgment that should have precluded it was the fact that the landowner was on notice of some issues with these handicap ramps, that there were some problems with them. And I cite to the Height case, which is a 2016 federal court case, but interpreting our law, our Ohio law. And that case, the court specifically talks about the duty to inspect, the duty to actually do things. And it says two things. It says the proprietor or one of its employees had actual knowledge of the hazard and neglected to give adequate notice of its presence or to remove it properly. Here, we believe there is evidence that they had actual notice. However, even if they don't have actual notice, or if the court decides that, the second part says the danger presented by the hazard had existed for a reasonably sufficient time to justify the inference that the failure to warn against it or remove was attributable to a lack of ordinary care. That court specifically talked about an exception in these cases, and it says it is an issue of fact as to whether or not defendants failed to conduct a reasonable inspection of their property, and whether or not defendants had or should have had constructive notice of the hazard. In this case, we took the 30B5 deposition of a representative of the landowner. And the landowner testified, and it's in his deposition, that at no time did they ever do any inspections of these handicap ramps. Now, that is directly contrary to the rules that Height tells us they have to do. And that it can be a reasonable conclusion that if they didn't, they were on constructive notice of that defect. So in the present case, that's a second reason that the trial court erred when it granted summary judgment. Additionally, there was an issue, and the trial court really relied on this affidavit of Dr. Park. Now, that affidavit was submitted in direct contravention of the local rules of Summit County, which state that in a reply brief to a summary judgment, you can't present new evidence and use that evidence to support your claim. And that's exactly what happened here. This affidavit actually had been executed months before they even filed their summary judgment, but they didn't use it to support their motion for summary judgment. They only used it to support their reply in an attempt to counter the testimony of Mr. Case. And it shouldn't have even countered it because, once again, you have two different sets. One says red, one says green. That's an issue of fact at that stage in the proceeding. So as we moved to strike that affidavit, indicating that it had been provided in contravention of the local rules. That motion was never ruled on, however, under our jurisprudence, that means that it was denied. But that was error. That local rule was designed to prevent exactly what happened here, from somebody sitting back and sandbagging and waiting until time for the reply, when you don't have an opportunity to counter any of that evidence, and to bring that piece of evidence in to state that X didn't happen. We believe that those are all errors that need to be resolved by this court, and that this court should reverse the granting of summary judgment and give Ms. Case, not her estate, because unfortunately she passed away a little bit in the proceeding, but an opportunity to have their day in court. I see that my time is almost up. I will reserve my 5 minutes.
All right, we'll have 5 minutes for rebuttal. Counsel, you have 15 minutes.
Thank you, Your Honors. Good morning. My name is Kristen Campbell-Traub. I'm here for Austin Center Condominium Association. The pleadings are a little bit confusing because Dr. Park had originally been sued in the action. That's one of the reasons he didn't want to get involved in the case by giving an affidavit again, and said, please only use my affidavit in the event that you have to. We had to because it was used for rebuttal to counter the statement made by Mr. Case during his deposition. And if you look at the court's opinion, the court didn't rely specifically on the affidavit of Dr. Park in making its decision. What the trial court did is say, Dr. Park's alleged statement is hearsay and completely impermissible for consideration in a summary judgment proceeding. That is absolutely in line with all of the case law from Ohio and Rule 56 itself. So the reason the court found that there was no evidence that Dr. Park said what he allegedly said was because it was hearsay and you shouldn't consider it. The problem with hearsay is that it's unreliable and perhaps untruthful, especially when submitted by a party who is trying to overcome summary judgment by a self-serving statement. In this case, we use the rebuttal affidavit to specifically show that yes, in this case, the self-serving statement was inaccurate and untruthful, which is why you shouldn't consider hearsay in the first place, which is simply what the court did. The court's analysis goes through a very detailed rendering of the facts here. There was no defect on the sidewalk. Any alleged defect, which there were two, wasn't the proximate cause of the fall, and 3, the condition of the sidewalk, whatever it was, whether perfect or imperfect, was open and obvious to both Mr. Case and anyone else on the property. I think if you look at Mr. Case's deposition, photograph A1 is very informative and frankly dispositive of the issue, because he marks in that photograph the handicap ramp that he is talking about. He looks at both of the alleged defects that are on the property, and one is a hump on the sidewalk that he says you can't see. Well, if you look at the photographs, you can see it from 50 feet away. Mr. Case said he immediately identified this issue after the fall, and he was able to take pictures of it both that day and when he went to the site later. The second alleged defect that Mr. Case circled is a jagged area of the ramp where he says must have been damaged by a snowplow. Of course, there's no evidence to this effect, and he is just assuming. So first he assumes that that is the area where his mother fell, and secondly he assumes there had been some kind of damage. But if you look at his testimony, you will see that whether that area of the handicap ramp is jagged has no effect on the facts of the case. Mr. Case marked that his mother was standing on the opposite end of the handicap ramp, which is where he identifies the hump. As we've indicated in our brief, there are at least a dozen cases in Ohio that say that a hump or a slow indication on a ramp, on a handicap ramp, is open and obvious, and it does not create inaction.
Were these two alleged defects the same issues that were raised in the 2007, I think it was, civil rights settlement?
No, absolutely not. In fact, this is not even the same handicap ramp that was the subject of the 2007 Ohio civil rights complaint. In the Ohio Civil Rights Complaint, as indicated by Douglas Carpenter, the Secretary and Treasurer of the Condominium Association, there are two buildings at this property. And building 105 and 107 had handicap ramps, and one was going east-west and one was going north-south. And what the Ohio Civil Rights Commission said is that you have to turn the other one so that they are both east-west, so that a person can leave one building across the handicap ramp, go across the parking lot, and go into the handicap ramp in a smooth, continuous fashion. So that is the handicap ramp that they made the complaint about. It is not this particular ramp. That was the only complaint that was made, and that was rectified by the Condominium Association. In addition, there is an Ohio statute where the legislature has specifically held that even if it had been the same ramp, you can't use that evidence in any subsequent proceeding. It is just like a defendant having a no contest plea in a traffic case. You cannot use that for summary judgment purposes in a subsequent civil case. 4112.05 is the statute that addresses that and says that you cannot use the mediation or remediation in a civil rights action to support a summary judgment action. Going back to the picture, if you look at the handicap ramp, Mr. Case says that his mother was not walking in that area where the jagged area is. She was walking where the hump was. And in fact, he said specifically, she is not walking, she was standing. There was sufficient evidence in the case from Mrs. Case herself, from the medical records, and from Mr. Case, that Reva had had balance issues prior to that. And in fact, she said, I don't even know why I walked out on my own. If I had been thinking clearer, I would have waited for my son, because that's normally what I did. I used him to help me with my balance.
Didn't you say also, though, that she went to take a step and she said they didn't have a step off the sidewalk, a place to get off the ramp or off the sidewalk? Didn't she also kind of indicate that, although many times she also indicated she did not remember what happened, but didn't she also indicate that she had gone to take a step and there wasn't something there when she took that step?
She actually indicated with respect to this fall, I don't know if I stepped in a hole, I don't know if I stepped in a jagged area, I don't know if I just stepped off, I have no idea. And we can see from where Mr. Case indicated on the photograph, she was standing in an area that very clearly does have a step-down area for a handicap, either wheelchair or walker, or someone just kind of shuffling along to enter onto the parking lot area there.
Well, so let's assume that we have two sets of statements from one person's deposition that there was ice there was no ice there. Let's assume it wasn't, I don't know, okay? What do you do then in a motion for summary judgment when you have both completely opposite statements?
You look at the burden of proof, and in this case, the plaintiff has the burden of proof. It was the plaintiff's job and burden and duty and responsibility to show the court why she fell. There are a number of cases outlined here in the brief from the Ohio Supreme Court and down through the appellate courts that say the plaintiff has the burden of proof to establish why she fell. And what the plaintiffs want to do here is say that simply because she fell down, there must be a defect. And there is no strict liability like that in the state of Ohio. They have to show what caused the fall, and they simply couldn't do it in this case. Even if you were to assume that she fell because there was no step off, or because there was a jagged area, or because there was a hump, every one of those issues is clearly identifiable in the photographs and objectively, because Mr. Case said that he was immediately able to see it afterward. So even if those issues did exist to become a defect, which we don't think is the case, those are all open and obvious conditions in the sidewalk that everybody could see and take heed and take caution to avoid. And Mrs. Case unfortunately simply didn't do that in this case, and we think she just simply stepped off the edge of the sidewalk and fell down, unfortunately.
But you have no idea.
No one has any idea what actually caused her to fall down.
But you've suggested now that you think she stepped off the sidewalk, and I think you suggested in the brief that you thought she just lost her balance. What you're doing isn't any different than what your alleging the plaintiff is doing, correct?
If that is the case, my argument would be I don't have the burden of proof to establish why she did fall, but the plaintiff does. So because my implication or assumption is just as likely as the plaintiff's, they cannot prevail in a motion for summary judgment. They simply haven't met their burden of proof. And because Mr. Case indicated himself that she wasn't walking, she was just standing and then fell to her feet, that scenario that she just stepped down impermissibly or awkwardly or with a balance problem, just as likely caused her fall as stepping on any part of the handicap ramp that we see here in the photographs. With respect to the striking Mr. Case's testimony, as we pointed out in the brief, she didn't completely disregard Mr. Case's testimony. The only statement that was disregarded was with respect to Dr. Park's alleged statement that there had been problems that he had complained of before. That is the context where that particular issue came up. And as the trial court very clearly indicated in its opinion, Dr. Park's statement was not considered, not because Mr. Case has dementia, but because it was hearsay and it was impermissible for Rule 56 purposes.
What about the court discrediting Mr. Edwards' testimony on the belief that he has dementia?
I take a different read than the plaintiffs. I don't think that the trial court disregarded his entire testimony. I think that that specific statement comes up with respect to talking about Dr. Park in his affidavit and that specific hearsay statement. She didn't make a general overall statement that I'm not going to consider any of his testimony. It was an offhand comment that probably shouldn't have been there, but it was an offhand comment with respect to that particular issue. Did Dr. Park make this statement? A, it's hearsay and you shouldn't consider it, and B, there is rebuttal testimony that was provided to specifically indicate that that was not in fact the case. Plaintiffs rely on the cases of Height and Stewart. Height is a federal case that is not binding on this court. The issue in Height, in addition, was the defendant's argument that, yes, there is a defect on the premises, but we didn't have notice of it. That's where that whole discussion comes up. In this case, we don't believe there was a defect on the property, and we are not making the case that we didn't have notice of what this handicap ramp looked like. We had absolutely notice of what this looked like. We saw it every day, and that was part of our maintenance of the property, but it's not defective. That is the argument in this case, so Height isn't even applicable. Plaintiff also relies on Stewart for the issue of notice, which we pointed out was specifically and expressly overruled by the Ohio Supreme Court in Lang versus Holly Hill. And as Lang pointed out, not only does administrative rule, like in this case, the Ohio Civil Rights issue, not create a private cause of action, it's negated by the fact that these issues were open and obvious in the first place. So we think the plaintiff's claim fails on a number of levels. First being not being able to identify the cause of the fall. Secondly, not being able to prove that any alleged defect on the property was anything more than a trivial imperfection which a person is expected to encounter. And three, negating the fact that it's an open and obvious condition that everyone could see and avoid anyway. So
When the court made the finding of open and obvious, did it cite those points that you've made today, that, the picture referencing the deposition picture and the deposition testimony of the son that he noticed it right away? Did the court make those findings or address those points in finding it open and obvious?
I don't know that the court specifically said photograph A1, but the court did have the entirety of the Edward Case deposition, which included the attachments and the photographs. So the court indicated that they had included all of the evidence in the assessment. So the trial court didn't specifically refer to that specific photograph, but did say that if you look at the condition as a whole, that the sidewalk was open and obvious.
Counsel, are you sure those photographs are in the court record?
They were attached to Mr. Case's deposition testimony, and I believe they were attached to our motion for summary judgment as well. For those reasons, we would ask that this court affirm the trial court's ruling for summary judgment in favor of the defendant. Thank you.
Thank you. Council, you'll have 5 minutes then for rebuttal.
Thank you, Your Honor.
It'll be running on the lowest circle there.
Perfect, thank you. I think what's important to note, based upon the appellee's argument, is they keep talking about the burden of proof, and that the plaintiff has the burden of proof. That burden of proof that the plaintiff does have is the burden of proof at trial, to prove these allegations by preponderance of the evidence. That's the civil burden of proof. She's conflating and ignoring the summary judgment rule, which has a completely different set of rules. It says that if there are issues of fact and there's differences in the testimony, you have to believe and side with the side that is saying this is true. Merely because they present a rebuttal affidavit of Dr. Park does not mean that the court is allowed to then ignore the testimony of Mr. Case. Secondly, this whole concept of we don't know how she fell. We do. Mr. Case specifically testified. Here's the questions. Did you see what made your mom fall, or did you just, yes, I did when I got out there. That's the testimony that Mr. Case presented. Just because he didn't see, because he couldn't see all the way to the ground when she fell, what it was, doesn't mean that he didn't know what caused her to fall. He got out there and he saw exactly what it was that caused her to fall. The second part of the argument that they make is that, well, either they're saying there is no defect, there is no defect, there is no defect. But it's a trivial defect if one exists. But if you don't believe that, we're going to say the defect is so clear that it's open and it's obvious. You can't have both of those things. Those are inconsistent. Either the defect is open and obvious, a huge hole in the ground that we all can see, that we have a duty to observe, or it is a defect that you can't see. Part of Mr. Case's testimony did talk about this hump that was right there. And it's not the normal hump in a handicap thing, it was another hump that was right there. And Mr. Case specifically testified that it wasn't readily observable because of the glare in the sun. He said he couldn't see that until he got out there, and then he saw it. So it's not an open and obvious defect. Furthermore, this whole discussion about, whether or not the court ignored Mr. Case's testimony. The fact that the trial court made that statement that Mr. Case suffers from dementia with no evidence, no argument whatsoever, no proof, that can only lead you to the conclusion that she said that because she's disregarding his testimony. There's no other point to putting that statement in there, unless she is pointing out that because of that, his testimony is not reliable. And that, in and of itself, is error. She made that up out of thin air. There was no testimony. In fact, it's not true. There's no testimony about it, yet the court said that to support her position that she's ignoring what Mr. Case said. Okay? Those are issues of fact. Okay? Furthermore, I do agree with counsel that Height is a federal court case. It doesn't have any precedence over this court whatsoever. However, it is very instructive because it's just like this case. They ignored the problems that they had with their handicap ramps and just decided not to do any inspections of it. In fact, their representative testified that not only didn't I do any inspections in the past, we haven't even done any since this event happened. That's his testimony.
Well, do you agree it was a separate ramp with totally different issues?
I do, Your Honor, and I've never said that it was this ramp. The point wasn't that it's this ramp. The point was they were put on notice that they had problems with their handicap ramps, which triggers a duty of them to inspect and make sure that the
It
ramps
seems like
are
it was
safe.
pretty specific, it was just the location and the direction the ramp was.
I agree with you.
Once they fix that, what other notice would they have?
Well, I think that puts you on notice to take a look
At everything.
at all of the ramps.
Council, you've used your time.
Thank you, Your Honor.
Thank you very much. Thank you, both of you, for being present today and providing the court with the arguments. The court will take the matter under advisement, issue a decision. In due course, the clerk of courts will mail you each a copy of the decision on the day of its release. And as you probably know, the opinions are also posted on the Supreme Court of Ohio's website. I want to thank you again for some very nice arguments here today. So